Wow, so y'all know Henry Dinkins is expecting a verdict in his case. He's accused of murdering Breasia Terrell. So the 15th, the judge is supposed to come back with a verdict, and he is having a bench trial, so no jury, the judge will make the decision. Now, I know you're not supposed to interfere with the jury while they're deliberating or any other time during your trial. I'm not sure how that works with the judge. However, Henry has written a letter to the judge while he's deliberating. His lawyer did not put in a motion on his behalf or anything like that. This is a letter from Henry Dinkins in his handwriting. And it is very long, y'all. They even got the envelope and, his prison cell address, and it is sent to the judge. Now, if the judge has read this and gave a response that he's going to consider it, we don't know. Let's see, because if I'm about to read all this, no. Okay, I'm writing you with urgency. Attention that the state has used deception and sabotage this whole case to fit their opinion of a theory, which I have proof if given the opportunity to show you their lack of honesty to the courts and the public. Okay. So he wasn't given the opportunity the entire time he was having the trial? Okay, first and foremost, I'm back to reading now, guys. First and foremost, the state did not obligate the court's order when my attorney filed for request for production and disclosed by counsel and pursuant to the Iowa Rule of Criminal Procedures 2142, stating the following item of evidence. If in possession and control of the state of Iowa are necessary for preparation, the defendant to inspect copies or photographs or exhibits. It's so small, okay? Or any evidence the state intends to offer in evidence at the trial or where obtained from or belonging to the defendant. Rule 1.517, consequences of failure to make disclosure or discovery. Okay, Rule 1.5171. Failure to disclose, or y'all know he copied and pasted this out of a law book in a law library. Who letting that fool go to the library? Well, I guess he has a right to, even though he's not trying himself, representing himself. But we know, we've heard Henry talk, so I think he done leveled up well in jail. And clearly he can read and write. Handwriting ain't bad either, but anywho. Okay, failure to disclose a supplement if a party failed to provide information or identify a witness as required by Rule 1.504 or 1.5083. The party is not allowed to use that information or witness to supply evidence at a motion, at a hearing, or at a trial, unless the failure was substantially justified or harmless. Okay, so I guess he's insinuating that they allow evidence from a witness that they have failed to identify as a witness as required. Interesting. Okay, so he should also point out what they did specifically, because he about to rule. Today's the 12th. We only got 3 more days and he about to rule. So he's waiting for an answer to then present the evidence. What if the judge turns it down? I would have put whatever the accusations are clearly and thoroughly in this letter if I was to write a letter. But, I wouldn't be on trial for such a thing. But I think it would have been wise for him to go ahead and tell exactly what it is instead of pointing out the rules that he claims that they violated only, because I don't think that he's gonna really, if he see what has happened Say, for instance, he said they failed to supply the witness information, but they used information from the witness as evidence, right? So he should say, here, they used this evidence from this witness and they failed to identify this witness. Now the judge can say, okay, this is exactly what he's talking about. Let me look over this and see if this is accurate, or if they properly withheld the witness's information within the rules of the courts, right? So he can decide right then and there if Henry has a leg to stand on his claims. But yet he took the long shot chance of what? In my opinion, further holding up this procedure. Because he's been doing this whole trial, y'all. He's been doing this before the trial started and all that, with his stalling tactics and asking for other lawyers, and then saying he gonna represent himself and this and that and this and that. So, I don't know. Okay. So then we go to D, the failure to act described in Rule 1.5174 may not be excused on the grounds that the discovery sought is objectionable. 1.502, disclosure of expert testimony, A, in general, in addition to disclosure required by Rule 1.501. A party must disclose to the other parties the identity of any witness the party may use at a trial to present evidence under Rule of Evidence 5.702 and 5.703. Oh, and 5.705. 3. Any exhibits that will be used to summarize or support the opinion, Rule 1.500, duty to disclose, required disclosure, 1.501. A, in general, except as exempt by Rule 1.500, i.e., or otherwise stipulated or ordered by the courts, a party must, without awaiting a discovery request, provide the other parties to all documents, electronically stored information, and tangible things that the disclosing party has in its possession, custody, or control, and may use it to support its claim or defense unless they would be solely for impeachment. Okay, so he's telling him the laws. How nice of you, Henry, to inform the judge of the laws. I'm not sure what good you think that's going to do the judge at this point in time, because the case has been completely argued, and you may want to save this for your appeal, because this sounds like appeal information. Now, I'm not saying he has an appeal, because I don't even know what Henry's talking about. Sorry, I'm trying to clean my lens. It's my OCD won't let it slide. But I don't know. Well, let's see. Anything to, he got to try, I guess. Okay, so he says, I will have to say, Judge Latham, that the state didn't provide at least 50% of those exhibits until the day of the trial. And there are still others that the state hasn't provided to us, the defendant. If given the no, you the only defendant, ain't no us, boy. Okay, unless we throw Andrea and the mama in, is that what? Yeah. No, I'm just playing. Okay, so if given the opportunity to prove this on the records, I can show the deception and how they sabotaged a lot in this case. Now, I showed you already where the state moved exhibits to fit their story in a trial. I have plenty more to show you and the public. Those exhibits were also given to us during trial and not before. That happens all the time. Okay? I'm not saying he don't have a leg to stand on with this claim, and I'm not saying it happened. Henry's saying it happened, but that happens all the time in court, and the judge decides right then and there whether he's going to allow it, and especially if there's no objection to entering the evidence at that time, the judge is going to allow it. So, before I continue, because we on page 3, we almost done. It wasn't that bad. Um, this he might need to say this for an appeal. Henry does not want that guilty verdict. Okay, this is clear. But he might pack this letter up and save it for his appeal. But we already see basically what his appeal would be, and so that gives everybody who would try and oppose his appeal a heads up on what he's going to go after. So Henry is not a lawyer. I don't know where he got this information from, but I can say the way he was flipping through those pictures, okay, and the way he was communicating with the lawyer during the time that the lawyer, his defense attorney, was cross-examining and things, I say he is thoroughly involved in this trial, as he should be. So he is working diligently, we can assume, to help get himself off of this. And I'm not even surprised by this letter, to be honest with you. Henry is not playing no games with y'all. Okay? He's not playing no games. So, Rule 1.1012, grounds for vacating or modifying judgment. He said, vacate or modify. Now, do y'all remember that Henry Dinkins tried to get an acquittal in the middle of the trial? Y'all remember that? And the judge denied it. I don't remember what those claims were specifically, but if I had to assume, it probably would be some of the things that are included in this letter, right? I'm not going to go back and look for the reasons he tried to ask for an acquittal, but somebody will, I'm sure, and we'll go from there. But we have a couple of days. It's not going to be that long before we are sure to hear something from the judge, unless he's going to push it back so that he can go over and consider this letter. I don't even know if he is required by law to even read this, much less consider it. But we'll see, because again, if he comes back with a guilty verdict, then y'all know Henry gets an appeal. AJ Armstrong has already filed his appeal quickly. It was like, the next day? So he didn't waste any time. I think you have 30 days to file for your appeal. So, we'll see. So he is saying you can either vacate or modify judgment based upon what I'm saying, because I got it. So I got the sauce on y'all, and this is not going to happen. I'm not going to jail for this. So, hey, 1.10125. Unavailable casualty or misfortune, preventing the parties from prosecuting or defending. Okay, so he says under Rule 1.1012, grounds for vacating or modifying judgment. 10125, unavailable casualty or misfortune, preventing the parties from prosecuting or defending. And 1.10126, material evidence newly discovered which could not within reasonable diligence have been dissolved and produced at trial. So basically what Henry is saying is the evidence that they did present to them during the trial was not given to them in ample enough time for them to examine it and prepare a defense if necessary against that evidence. The burden of proof is on the state. The prosecution, the DA, they have the burden to prove such a thing. And if they are presenting evidence as proof, then the defendant is supposed to have privy to that evidence so that they can review it and decide whether or not they want to try and make a defense for it if they think it's substantial enough that it would affect a verdict. And he is saying that he was not given that evidence in enough time so that they could do their reasonable diligence to decide how to go about their defense case. So, in conclusion, he says, Judge Latham, I was also looking under the official comment enactment 1943 federal practice. We come now to the question of enforcement without adequate sanction. The procedure for discovery would be ineffectual under Rule 37, and any party who seeks to evade or thwart a full and candid discovery incurs the risk of serious consequences, which may involve imprisonment for contempt of courts for disobedience of a court order. Now, the entry of an order that designated facts can be taken. The entry of order that designated facts be taken to be established. The entry of any refusing the disobedience party the right to support or oppose designated claims of defense, strike out. Pleading by default, dismissal. Okay, he should have put Love Henry. Why not? Guys, this is Henry Dinkins. All right, and so he's saying if you don't, y'all got some consequences coming according to the law. That's what he's saying. Okay, so, man, just a couple of days. We gonna see. Let's see what the streets is saying about this real quick. Okay, so I have not found anything other than the reporting of this letter. So it would be nice if the appropriate type of attorney would give their opinion of said letter and, the entire procedure or whatnot. But, we probably not going to get that. Today is Tuesday. We are waiting because on Friday the judge is supposed to come and give us a verdict. Brigasia, honey, he is trying. But, I think we good here. I honestly do. I know the case doesn't give 100% proof against Henry, but the evidence is great. And we do see Henry is trying. And I can't not say that it isn't impressive on him and his lawyer's behalf, because they didn't have much to go on, but they worked very well with what they had available. And as you can see, Henry is still pulling shots, okay? Henry is no stranger to the courts. He is no stranger to jail. And for some reason, they kept letting this dude out. And he ran amok when he was supposed to be registered as an offender. And he was able to work his way onto getting a woman to allow her daughter to come and spend some time with him, including staying the night. And months and months and months later, her body, the rest of her body, her skeletal remains with very little soft tissue, and even some of her body parts missing, including her toes that was eaten by wildlife, was discovered. Okay, so hopefully Friday we'll get a guilty verdict, and then we'll get past this appeal process, and he doesn't win that either, and we might hear some great stories about wonderful times he's having in jail. All right, see you all Friday.